On the record in the matter of Orbit Leasing versus Zyra Davison, 13-03825 GC. Appearance, please.
Good morning, Your Honor. Jeremy Chisholms, P74670. I'm the attorney of record for the plaintiff.
Zyra Davison present. Okay, this is the date and time scheduled for a hearing. This is for a motion to set aside an installment payment plan. There was an objection filed by the defendant. The objection essentially indicating that they had lost their job, fell on some hard times. However, not sufficient enough to overcome the threshold for the original request to set aside the installment payment order. So the objection will be denied. Is there anything you wanted to say for the record?
Judge, no, I guess for whatever it's worth, there has not been any further payments made since the motion was filed. And the last payment was back there on January 31st of 2025. So it's about a year since a payment's been made.
I assumed as much as then if they had appeared today, I would have seen if they could have brought.
I'd have been happy to talk to them and try to get it worked out.
Yeah,
balance is down now, Judge.
Maybe to move forward, but with that being said, they've even failed to appear today. So the objection to setting aside the payment plan is denied, and the payment plan will be set aside. Any additional matters for the record?
I appreciate it, Judge. Have a great day. Merry Christmas, everybody. Thanks.
Same to you. Let's see, LVNV Funding LLC versus Daniel Peeler, 25-03404. Council appearance for the record.
Good morning, Your Honor. Andrew Cates, P78292 for LVNV Funding.
Is there a Daniel Peeler present? Okay, no one's appeared today for the general civil pretrial. Did you want a default judgment to enter?
Yes, Your Honor.
Default judgment will enter. You can provide that via my file.
Thank you, Your Honor.
Thank you. You're all set.
Can you guys hear me now?
I can.
Okay, sorry. I tried to use my computer and I don't know what was going on. I'm on my cellular device now.
What's your name?
My apologies. My name is Timia Verser.
Okay, thank you. You can mute your device until I call your case.
Okay, thank you.
No problem. LVNV funding versus Michelle Letts, 25-03420, council appearance.
Good morning, Your Honor. Andrew Cates, P78292 for LBMB funding in this matter.
You're Michelle Letts?
Yes, ma'am.
Okay, you don't have an attorney, correct?
No, ma'am.
This was set for a motion to set aside a default judgment. I do have a handwritten motion that was filed by you,
Yes, ma'am.
indicating that you're almost 61 years of age with some health conditions, and you often forget appointments, and you don't even remember a court date notice and couldn't find one. You called the office of LVNT for court date and explained that you make less than 930. Was that what that said?
Yeah, I brought everything with me.
Okay, a month and heard nothing until this. You're requesting the motion to be the default to be set aside.
Yes, ma'am.
Okay. Sometimes do not eat every day due to my income. I wrote this credit card people 4.5 years ago when I got sick. What can I do? Okay, counsel, you did receive a copy of the motion. Is that correct?
That is correct, Your Honor.
Did you want to respond to the motion?
Your Honor, well, I'm sympathetic for the ability to pay, but the ability to pay is not a reason for a judgment to be set aside. There really isn't a meritorious defense that is being presented in the motion as required by court rule, so there would be no real issue for trial, so there's no real reason to set aside this judgment.
Okay, thank you. So for your information, Ms. Letts, in order to have a default judgment set aside, and I see here, it looks like there was a complaint and summons that was served. Let me see the address it was served on. Let's see. Are you on Davis Ave?
Yes, I recall that.
Okay, so that's your notice of a lawsuit. And at the bottom of that complaint and summons, it gave you instructions that you needed to respond or appear and file what they call an answer within 21 days. You never did that.
No.
And so that's how you got the default judgment. So when you get a default judgment, whether it's because you didn't get the service or you forgot you got the service, whatever, in order for the court to now grant your request to set it aside, you have to give me two things. One is good cause as to why you defaulted, which you've given me. Due to your age and your health, you tend to miss, court dates and appointments and stuff. But you also have to give me what's called a meritorious defense to the actual lawsuit, meaning, example, they say I owe this, but I don't owe this because I paid it. Or they say I owe this, or I was a victim of fraud, or it's something like that that shows me that you actually have a defense to the lawsuit. What you wrote suggests that you do agree that you owe this debt. You just don't have the ability to pay.
I don't yet.
Okay,
yes.
so I'm not allowed,
to-
got it. I'm not allowed to set it aside for that purpose.
Okay.
And so understanding though that you do have some financial situations, what you can do is meet privately with the attorney and maybe you can come to an installment payment plan. Maybe if you can make, some minimal monthly payment that will keep you from being garnished.
Yes, ma'am. That would
Okay.
be wonderful.
Okay, so we'll get you on a private meeting room so you can talk about your finances privately, okay?
Okay, thank you very much.
You're
ma'am.
welcome. But for the record, I do have to deny the motion, okay? But we'll see if
Yes,
we can come
ma'am.
to a payment plan. Thank you.
Your Honor, shall we submit an order to that effect, or will the court be sent?
Yes, you can submit an order and then we're gonna get her on Zoom to meet with you now. Because it's named the same way.
Yeah.
Exactly. I knew that. I was like, well, it's never came in that way. Well, who changed the name? David, can you unmute? Because we don't know which one is. There we go.
Yes, sorry.
Can you change the name on the iPad because it's got the same name as the court?
Oh, okay.
Thank-
Let me do
Yes,
that.
it can't say, yeah, just put courtroom iPad or something.
Okay. Let me do this.
And then we can know which one to put in the breakout room.
Okay.
Thank you. God bless whoever that is. Okay, on the record in the matter of SK Lansing Limited versus Benika Fombi, 25-05900.
Good morning, Your Honor. Alex Tolzman on behalf of the plaintiff.
Okay, I'm not sure if you're able to get through. Are you able to get up here right now? Or I'll just wait for my court officer, he'll assist you. No problem. She's in a wheelchair, so we need to wait so she can get assistance coming forward. In the interim, today was the date set for a motion hearing, and this was for a motion to set aside a default judgment. Counsel, you got a copy of that, correct?
I did, Your Honor, yes.
Is David coming back? Let's see. You put that person in the breakout room? Yeah. Okay.
Try my son to move the door.
Oh, if you have someone, oh, there he goes, right there, actually. Can you assist her coming up, please?
I don't know if I can sit back there.
No, you can just stay right there and we just need to be able to pick up your voice to that mic right there, okay?
Right over here?
Yep,
Okay. Where do you want me right here?
yeah, right there, that way you can hear me,
Okay.
correct?
Okay.
Okay, very good. Okay, again, this was a date set for a motion to set aside a default judgment. We did receive your motion, Ms. Bombi. You indicated that you missed court because your phone was not working and because if you're in a wheelchair, you had some limitations with transportation.
Yes, ma'am.
And that you said it was hard getting out and getting a ride. You have not paid your rent because I believe it's a ceiling.
Yes, the ceiling, the ceiling's falling in. They came out to do an inspection almost 2 years ago. At the time, it was Lansing Housing. I guess it's S&K now. When they came to do the inspection in the attic, like replacing insulation, they stepped on in areas that caused the ceiling to fall in. They did that.
Okay, so I'm just trying to read what you wrote. You said it says because I can't read this word, something roof.
Right.
Is that falling roof? I don't know what that says. Something.
Yes,
Seal something falling in and a lot of water damage.
yes, ma'am. Yes,
So you're
ma'am.
having water damage or water coming through your roof?
Water has come through the ceiling, which has come from the roof. From what I was told from when they got in the attic, the company that came out to take out the old insulation because it was so moist and so wet. They said that that was coming from the roof. It's old and worn, needs to be replaced.
And that's been going on for 2 years?
2 years. So since then, first it started off just that area in my bathroom. I do have photos. They put a temporary fix of like wooden slates, wood to hold up the foundation temporarily. They have been brought out because Lansing Housing could no longer afford to manage what they call scattered sites. I live in a scattered site, which is a home.
What does that mean, scattered site?
It's a house.
Oh,
So they
okay.
call those scattered
Got
sites. So they sold them to S&K, but their maintenance still manages, and they also send out contractors. I believe that, and I know for a fact, the ball is just dropped. I mean, they sold it because they can't manage it.
Okay.
So I've received neglect and abuse,
And you have mold?
mold, water damage. I sound like this. I have medical documentation, my psychiatrist that I see, my home care providers. I don't have all that with me today, but I'm hoping that either A, they'll set a further court date.
This is
for
no
that to be
repairs have been
submitted.
done?
The temporary fix in the bathroom, but now it's continued throughout the home. The ceiling.
When you say continue, the ceiling
The
issues
ceiling,
continue?
yes,
Got it.
falling in, very
Thank you.
unsafe.
Ms. Tolzman?
Yes, Your Honor, we received the defendant's motion. My understanding is that there has been some issues on SK Lansing's end to get repairs done due to the defendant not letting workers or the apartment in because of the assumingly good cause and meritorious defense set forth in Ms. Fonby's motion. I don't have an objection to setting this out for a hearing.
Thank you. You have provided the court with good cause as to why you missed your court date and a meritorious defense, being that you're alleging there are some conditions to the habitability of your unit. And so because of that, the court is going to grant your request to set aside the default. This will now be set for a hearing date. And so I recognize you have some limitations. You do have the, for a hearing though, you must appear in person for hearing regardless. So you need to make sure you can get, accommodations to get you here for your hearing date. We're going to get you that date today. Also, did you make the pretrial date? Probably not.
No, ma'am, I do not.
Okay, so before you leave here today, I'm going to play a video for you that will go over your rights. It will also advise you of resources that you may be able to access. And we'll get you contact information. It'll be on the video so that you can contact legal services. Because typically they would have been here to do an intake with you to see if they could represent you at no expense to you. But because you missed the pretrial date, you missed that opportunity, so you'll have to reach out to them and see if they can assist you, and we'll get you a hearing date.
January 7th at 8:30.
January 7th at 8:30 is going to be your hearing date. And then you hang tight. I'll play the video for you in just a moment, okay? Do you have any additional matters for the record, Ms. Tolzman?
No, Your Honor.
Okay, thank you.
Thank you. Have a nice day.
Same to you.
I have a question. Can I ask you a question?
Sure.
Am I allowed to stay in the home until that date?
There's no eviction, so I'm setting aside the default that it's still moving. So until the court orders an eviction, you do not have to move unless you want to move. And so the hearing is the date and time for us to determine whether or not you lawfully need to move, or if there was or is a habitability issue that could abate the amount that they claim that you owe. Okay?
Okay, all right. Thank you.
You're welcome.
Move this way.
Yeah, if you want to move back to where you were before.
Thank you.
And then once I get these other people all squared away, I'll play the video for you, okay?
Thank you.
Oh, okay, well, she can stay over there then.
Ma'am,
I'm coming over.
okay.
Okay,
Where do you want me to go?
Oh, yes, you can see.
Thank you, Judge.
no problem. Okay, let me see here. Counsel, I think you returned with Ms. Letts. Did you all come to a payment arrangement at all?
Yes, Your Honor.
Oh,
Okay, back on the record in the matter of LVNV funding versus Michelle Letts. Counsel, did you want to put the agreement on the record?
Yes, Your Honor. The defendant and I have talked in a breakout room and come to an agreement. The defendant will pay the amount due in the balance in installments of $25 a month, the 15th of every month, starting January 15th, 2026. And I did discuss with the defendant about proceeding with signing on the order on her behalf uh, for entry with the court.
Okay, that's what you want to agree to, ma'am?
Yes, ma'am.
Okay, and you've given him permission to sign on your behalf?
Yes, ma'am.
Do you have any questions for the court today?
Just, no, I don't know where to send the money and I need an address.
Oh, okay. Yeah, we'll send you payment instructions in the mail, ma'am.
Thank you, sir. No,
Okay,
that's
thank you.
it.
You're all set. Thank you.
Thank you very much, ma'am.
No problem.
Thank you, Your Honor.
Thank you. Tamia Verso is online. Let's see. On the record in the matter of Gateway Financial versus Tamia Verso 17-03898 GC. Can I have your appearance, counsel?
Good morning, Your Honor. Adam Kanaszewski on behalf of Gateway.
Okay, and then Ms. Verso is present via Zoom. State your name for the record.
Yes, Tamia Verser, Your Honor.
And you are without counsel today, ma'am?
Yes, ma'am.
Okay, thank you. This was a hearing that was set because, ma'am, you filed an objection to a garnishment. You stated here that you are objecting to the garnishment issued on June 18, 2025. You believe that the writ was not properly issued or is otherwise invalid because you said that they have been disputed off your credit report. The debt is over 10 years old and they have garnished enough money from you. When you say they've garnished enough money, what does that mean? Have you satisfied the debt?
Well, the thing is, they've been garnishing since 2018. And like the debt has not moved. You know, it's been the same. They've taken over $4,000 from me. They resold the property, got money back for the property. I've called several times over the year to try to settle the debt. Like I've called them maybe like 4 times within a time span of 2018 to now, and they just be irrational. I feel like they're being greedy about the situation, And I'm just, like I said, I it's off. I disputed everything off my credit report. Again, they don't want to, they never wanted to comply with the debt consolidation. And I just feel like as much money as they took from me, because the original judgment was for like $6,000. They took more than half of that from me over the years. And it's just like the debt has not moved because the interest just keeps piling up, piling up, piling up, piling up. And I'm just ready to bury the hatchet because it's putting me into a financial hardship every year because of this.
Okay, thank you. Counsel, did you want to respond to her motion or her
Um,
objection?
Your Honor, this is a objection to a state income tax garnishment that we filed. I didn't hear anything that amounted to a valid objection. I will note that we have garnished income taxes, state income taxes, since the judgment was entered. However, we haven't received any other voluntary payments outside of that. The judgment is valid. It's been in place for numerous years. It was in excess of over $6,000. My review of the file shows that her principal is down to $494, but there does remain just over $3,600 in interest. So the balance is $43,3687 right now. So it is less than the original judgment, but as she correctly stated, it does collect interest in the interim, and when they're only getting state income tax garns, the judgment doesn't get fully paid off. So I'd ask that the objection be denied, Your Honor.
Thank you. Okay, so Ms. Verser, so that you're clear as to how this works, you were originally served with a lawsuit, and this was for a debt, it looks like for a vehicle, 2006 Audi,
Yeah.
that must have been repossessed. I recognize it probably was sold, and then there was a balance that accrued. When you were served with a complaint, it looks like you defaulted, meaning you never responded to the lawsuit. And so a default judgment was entered back in 2018. I'm going to also, I'm sorry.
I'm sorry, I don't mean to cut you off. I was in between cities at that time.
You do mean to cut me off then.
I apologize. I was just trying to
Okay.
give you a valid reason to why that happened. I didn't mean any.
Why what happened?
I was why I wasn't a correspondent with the judgment. I had just had my daughter, and I was in between cities at that time. And when I did get the letter, it was too late. It was already, the court date was already passed. And then I tried to reach out to Gateway personally to try to settle, but they really didn't want to hear it. They just wanted to proceed forward with the motion.
Okay. What your recollection is not the same as what the court records reflect. So I have the records here from 2017. It says that they served you personally. A court officer served you personally with the lawsuit on Tuesday, November 28th, 2017 at 1300 hours at the address that you currently still live at.
I was full-term pregnant, in and out of the hospital. So I don't recall being served anything. I had my daughter December 2nd of that year.
Okay. I recognize that you may not have recalled, but that doesn't dispute that this is a affidavit, which is a sworn statement from the person who served you, indicating that you were served personally at the exact address that here in 2025 you still live at, and the time and date that you were served. So there's no reason for the court to dispute that. The other thing is, even if there was an issue at this point, you were so beyond the realms of being able to adjust or attack that, because if you receive a default judgment, then paperwork would have went to that same address from the court now telling you that the default was entered, and then the court rules then would have given you an opportunity to come in and request to have that default set aside. So I don't know if you were here or paying attention to the other two, a couple of cases I just did where people requested to have default set aside. There is a limited time frame after a default is entered for you to come and request to have the default set aside. You got to give the court good cause and a meritorious defense, and then the court then can do that. After that timeline, you can't request to have the default set aside, and you are well beyond that. The other thing that the court rules do not allow you to do is when it doesn't allow you to use an objection to the garnishment to attack the underlying debt. And it says that in the court rule that allows you to file an objection. And so that's why the paperwork that you receive, which is standard court paperwork for it, gives you the A, B, C, D, E, F options. Those are the only options that you have to get a objection set aside. You've got to provide evidence that either the funds were are exempt property or protected by some law, so that's why they can't be garnished, or that there was a bankruptcy proceeding that prohibited or discharged this, and so that's why your fund shouldn't be garnished, that you already in an installment payment agreement. And so typically in an installment payment agreement, which installment payment is just a payment plan. And once you're in that payment plan, that they won't garnish you because it says that on there. This will prohibit any garnishments. Or you can show the court that the maximum amount of permitted by law is already being withheld by another court order, meaning you might have multiple debts or multiple liens, and that the maximum that the court or the law allows for you to be garnished is already being held by another court. Or you can show me that the judgment has been paid, which is why I asked you about your statement that you've already paid enough. I wanted to know, are you saying that the judgment had been paid? And that's not what you provided me. And then what you selected, which was that the writ was not properly issued or that is invalid. Unfortunately, the reasons that you gave do not amount to that. The writ was properly issued. I think there was another supplemental document that you attached that indicated that you believe that the debt was already beyond the statute of limitations when the plaintiff filed the suit. Again, the court rule says that you cannot use the objection to attack the judgment, so I can't consider that argument at this time. And then you also said a judgment entered on a time-barred claim is void, and then you said interest and fees are added to be an unenforceable claim. Again, this was, to the best of my knowledge, filed within the statute of limitations. And additionally, even if it wasn't at this point, you had to appear during the actual case to attack that, meaning when the case was filed or within that default judgment period that you could set aside it to attack that, and you did not do that. So unfortunately, you've not provided the court with a valid reason under the court rules for me to be able to grant your objection. And I do recognize that there's a pretty hefty statutory rate here of interest that's accruing, and that's why your principal is so low, but your interest is so high at this point. You've not been making any voluntary payments. And so maybe you and the attorney for the plaintiff can meet privately, and you can get into what I've just discussed with you earlier, which is an installment payment plan, which is where you voluntarily agree to make some monthly payments, and that will prevent them from maybe garnishing your money, and then also help you get this behind you. But that's up to you and counsel for Gateway to see if that's something that you can resolve. Otherwise, ma'am, you can continue to be garnished until this interest is finally paid, and at the rate it's accruing, it's going to compound on you. Do you understand that?
I thought that they only get 10 years to garnish.
They do not get, no, they do not. So a judgment is good for 10 years. And then the law of the state of Michigan allows them, if they file before that 10-year time period, to request to extend the period, which I don't write the law. I personally don't agree with the law, but the law is the law. I don't think that the state where I'm from, there's a statute of limitations, but the state of Michigan, where I live and where I work and where I enforce the law, says that they have the ability to request and to use that judgment for 10 years. And then if they come before that judgment expires, they can request to have it extended a whole nother 10 years. So literally this could follow you all the way to your grave if they keep filing an extension.
I just don't understand how what is the interest rate on this? If it's only $400 principal and $3,500 in
The judgment says the statutory interest rate was 13%.
yeah, and so it's just like when they garnish, nothing's going to the interest, everything's going to the principal, and that's how they keep me financially binded to the contract. It's like an anchor on my ankle, and that's how they bury you under. And I just feel like that is just like very, very, very like absurd and like inhuman. That is
Let
insane.
me remind you, ma'am, let me remind you that you took out a loan for a vehicle, a 2006 Audi, that you purchased with the interest rate of 21.95%. You signed that agreement, ma'am. That's 22% interest.
I was young. It was my first car, and that
it's an expensive lesson to learn, ma'am. I understand that, but you can't now put it on them. It would be in your best interest to get in an installment payment plan to see if that can help you resolve the underlying. Maybe try to come up with a lump sum payment to resolve it, because again, they have the right to, the statute says they can request the interest. So there's nothing I can do. I can't waive statutory interest.
I've tried over and over again to come to an agreement, but they won't budge on the interest.
Okay, well, I can put you in a private meeting room with Mr. Is it Kenozuski? Did I say that right?
Yeah, Your Honor. Being that this was just an objection to a tax card, can I give her my office phone and she can just give me a call?
Have you been able
I would rather settle it. I would rather settle it today.
I was gonna say, I want you to go on that she because she's alleging that she's been trying and it's not been lucrative. I think a conversation needs to happen today.
Fair enough.
Thank you, Your Honor.
I'll put you in a room. That was she was talking motion is set aside with all this stuff. Okay, this is Midland Credit Management versus Jackie Street in 24-04321. Counsel, is counsel present on this? No one's here on behalf of Midland? You can have a seat. supposed to be a periodic, at least that's what it says, it's a periodic what? Objection to periodic payment, is that, you're requesting installment payment order, ma'am, is that what's going on?
I'm requesting.
Or are you
that the
objecting to a garnishment? I'm
yeah.
trying to find, okay. Oh, so you didn't use the actual form, okay, that's what's going on, you did a handwritten form. There was a garnishment and you are objecting, and the reason for the objection is what, ma'am?
Because I tried to make payments to them. And some of the payments were sent back. I don't know why, but the last payment I tried to make, when I called them and I told them that it would be late, and I still tried to make it, and it was sent back, so.
Okay, it looks like this was for an income tax garnishment.
No. They were garnishing my paycheck, and I work part-time.
I do see a periodic garnishment and an income tax garnishment. Okay, and so you were never actually on an installment payment plan?
Yes,
You were?
yeah.
Okay, what was the payment plan? I don't think it's filed with the court.
It was 3148.
That's how much you're supposed to pay monthly?
Yeah,
Since
and
and when I say installment payment plan, I mean, since the default judgment was entered, you were in a agreement with the creditor to make payments on that judgment?
no,
Okay, that's what I'm talking about.
no, I was making payments prior to them doing it.
Okay, so then they served you with the lawsuit, you never responded, so you got a default. You recognize that?
No, the first one they sent me, I did respond, and that's when I went on a payment plan.
Who did you respond to? Because the court did not get a response.
But this was back in January of this year.
No, this is from 2024, ma'am. You were served with a lawsuit or a complaint June 17, 2024.
Actually, that's when I started with the payment plan, was in 2024. Because I have receipt.
What payment plan?
With Midland.
You had a payment plan of what in 2024?
On 10/20/24, I sent them $100.44, and they sent it back.
Okay, which is makes sense because they served you with a lawsuit in June. When did you enter a payment plan with them?
I'm thinking it had to be around the end of 24.
It couldn't have been because they sent it back in
Yeah.
24. So the payment plan would have been before then, man.
But it was, well, I started making payments. Some of them they took, some of them
What
they
payment
sent
did they
back.
take?
They took 31.54.
No, I want to know what month.
Oh, okay. They didn't start taking them until January
Of what?
of this year. They took 31.54.
January of 2025?
Yeah.
They took it up from where? Your account?
Yeah,
Okay, and they've been taking it every month?
yeah. And
Well, let me
but
see
then
what
they
you have.
started sending them back.
I'm confused.
Yeah, I am too, because I was on a payment plan, and just like I said, the last one I tried to make a
Okay, so
$35.
this says here, even what you have here says that there was a judgment in 2024. This paperwork you have lets you know that you received a judgment. You
Mhm.
got a default judgment because you were served with a lawsuit, you never responded. So default judgment would enter. And so it looks like they were taking some payments.
Yeah,
It looks like they reversed one. Some they
because
took,
when I talked to them, they said they were gonna stop the judgment if I set up a payment plan, and that's what I did.
okay. Based on what you're saying, they're not here to dispute it, so I will note that you were supposed to be on a payment plan and they were gonna stop the, you believe they were gonna stop the judgment, and so I will grant your request. You know what I'm saying?
And they have taken so far $568.44. And when they took over this account, that's how much I owed them at the time. But with the interest and the fees and which brought it up to 900 and something. So actually, I paid them what I owe them with the interest, but it's just the fees now that I'm paying.
Okay, so I'm gonna note that. I'm gonna grant your objection based on what you're saying, and in the absence of the plaintiff to make or add their position to this.
Thank you.
Be advised that that doesn't mean that they won't come and try to refile or request a new hearing. And if they do, you come back with your evidence then.
Okay.
Until then, I will set aside the garnishment.
Okay, thank you.
You're all set.
So they could still try to sue me for the
Well, you've already been sued, man. And they already have a judgment.
yes.
What I'm setting aside, which is your hearing was to set aside or to stop the garnishment. I'm stopping the garnishment.
Okay. Thank you.
You're welcome. Form to stop the garnishment, because she didn't use the standard form for her objection. You're all set, man.
Your Honor, was I free to leave?
Yes, thank you.
Thank you, Judge.
Amber Perez, present. Okay, this is Coronado Gardens versus Amber Perez, 25-06408. The council appearance, please.
Good morning, Your Honor. Marlena Shum for the plaintiff, P69505.
And your name for the record, ma'am?
Amber K. Perez.
Okay, so this was a motion to set aside a judgment. You entered a consent judgment, is that correct? You said the judgment you believe is the result of management's failure to perform a required HUD recertification. Under HUD rules, tenants cannot be charged increased or retroactive rent when management is at fault. The property had no management from August through August 2024, making recertification impossible. New management failed to contact or process recertification from August 2024 until November 2025.
Yes. The dates are a little off. I had to go back and research so I can have the correct dates. Yes.
You look at your consent judgment really quickly. It looks like there was a consent judgment. Counsel, did you want to respond?
Yes, Your Honor. So it appears that Ms. Perez has essentially filed two motions, one motion to set aside the consent judgment and one motion to dismiss. The motion to set aside the consent judgment, she says that she felt threatened and she didn't understand the terms of the agreement. Your Honor, Ms. Perez was treated with the utmost of respect and civility. We had I appeared at that hearing. We had a very cordial conversation about the amounts owing. She told me how much she could pay. We drafted the agreement around her conditions. The agreement extended over 2 years. This is the longest payment plan that I have ever entered into in my career. She asked for this very extensive payment plan to be able to get the monthly charges lower. I worked with our representative who drove all the way in from Indiana to be able to get this approved. The payment plan that she proposed required very extensive oversight from the community, was incredibly generous.
When you say she proposed, you're talking about Ms. Perez or your client
Yes.
proposed?
Yes,
Okay.
Ms. Perez told me what she could afford, and based on the small amount that she was able to afford, based on the amount owing at the time, which was about $16,000, we came up together with a payment plan that extended over 2 years. The payment plan details were extremely clear and concise. These were the terms that she had requested based on what she could pay. And we entered into those terms on the record. I'm not sure what she didn't understand or how she felt threatened from a very cordial, respectful conversation.
Thank you. How did you feel threatened? Yeah.
I wouldn't say per se threatened, I would say cornered. I did stress to her that right now I'm seeking disability and I have no income.
Okay.
And I explained to her that I had no income, which is why I'm here with you today. It's been that way for a while for me. And I do not, even though she was very kind, I won't take that away from her. She was not receptive.
So you felt pressure is what you're saying?
I did.
Okay. And you're saying you didn't understand your rights, which is your right to have a trial. You could have demanded a jury trial. You also have the right to be represented by an attorney, which you would have had to waive those rights. You didn't understand those rights, ma'am?
I did. It's my first time ever having to be in something like this, and I'm alone.
Okay. As it relates to the motion to set aside the judgment, the court's going to grant it. She had 3 business days to return to the court if she realized after she left here that she misunderstood her rights. She did that. She misunderstood her rights. The court's going to grant that. The court's not, however, going to dismiss the case. It'll be set for a hearing. If you want a trial, you need to go down and demand a trial, but at this point, it'll be set for a hearing, okay?
Yeah, I also add one more thing.
Yes.
I don't have counsel right now. I'm struggling to try to find someone, legal aid, so they're so busy they couldn't take my case. So I'm essentially on my own, but I will say that there is very serious reasons why I do not owe this money.
Okay, you just need to bring the evidence of why you believe you don't owe the money. You don't have to have an attorney to show me the evidence. If you got proof that I was willing and available to recertify, but they didn't make that an option for me. And so now they're trying to retroactively charge me. If you bring that evidence, I'm pretty smart. I can figure it out.
I have all of it here if you'd like it today.
Well, today's not the date set for the hearing. And then also we need to give the plaintiff and their attorney the ability to be here for a hearing. So we're going to give you the hearing date today, okay? The next court date, all right?
Thank you very much.
Your Honor, I wonder if it's possible to request the contested hearing by Zoom. So one of my witnesses drove, I think, about 5 hours for the last hearing. And that would be very helpful if we could conduct it by Zoom.
I don't conduct hearings by Zoom.
Okay. I would need to just check with them. I believe we have a representative who is in the Zoom courtroom from Coronado Gardens.
Yes, that's fine.
January 7th at what time?
8:30.
At 8:30.
Which day of the week is that?
Wednesday.
January 7th at 8:30. Thank you, Your Honor. See you then.
No problem. We'll get you a notice for, and you're all set, okay?
Thank you.
Thank you.
So,
What time you said it was?
oh,
8:30?
this is.
Thank you.
That bitch. Wasting all this time.
You're welcome. Okay, ma'am, I'm gonna play the video for you now, okay?
They have a quick question. Do
Yes.
you know about how long we'll be? Only because the person that brought me is waiting.
It's like 3-4 minutes. Mhm.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney, handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Advent House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838. Option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.